Hello, everyone, and thank you for joining us for today's presentation as part of the Industry Insight webinar series. The topic this time is Compliance Pitfalls, What You Don't Know Can Hurt You. Tomas Suros, Chief Solutions Architect for Abacus Law, will be speaking today. As Chief Solutions Architect with Abacus Law, Mr. Suros applies his technical, legal, and business acumen to define business requirements and achieve cloud-based practice automation for his clients. As the spearhead of a global sales engineering team and while working daily with Abacus's client-centric sales teams, he defines business, technology, financial, security, and usability solutions for Abacus Private Cloud, mobile, and legal practice area-specific platforms. Mr. Suros earned a BA at Tufts University and a JD at the University of California Hastings College of Law and is a member of the State Bar of California. In his downtime, he stays active with his daughters as an avid surfer, triathlete, snowboarder, and scuba diver. The presentation today will be followed by a Q&A. Please enter your questions into the question box in the webinar panel on the right side of your screen. All questions will be addressed at the end of the presentation. We're recording this webinar and we'll be sending a video and a follow-up email in a few days. We'll also post a video on our blog at www.lawtechnologytoday.org. Thank you all for joining us. We'll now begin the webinar.
Hi, everyone. Thanks for showing up today, and I apologize for the initial confusion about the start time. We'll jump right in. I want to cover the agenda quickly. We'll do an introduction, kind of a background, a little bit about Abacus Nix and myself. We'll touch on compliance triggers, looking at the general duty of care to protect client information, as well as HIPAA and HITECH Act requirements. We'll touch on non-compliance repercussions, and then I'll really focus on how you can best leverage technology, both from a best practices application standpoint and leveraging expertise and other available bits of information in the marketplace to help you mitigate risk, because a lot of this is knowing exactly what your exposure may be and then having plans in place should, oftentimes it's a when, not if. Knowing when and how to protect yourself oftentimes can be the difference in controlling compliance and your exposure. And then finally, we'll save some time at the end, and as Austin mentioned, don't hesitate to type in your questions. We'll take as many as we can during the time we have. So let's jump right in. First, I want to just give a little background about Abacus Next. It's a turnkey private cloud technology solution. We combine kind of software expertise as well as security expertise, and we create private cloud environments that are in essence hosted for your firm, where your data, your client information, your software tools, and the kind of security controls, right? Proactive maintenance, management, encryption, those kind of things that we'll discuss later are inherent in the technology. So it's something to think about as we go forward. All right, so the first step, let's talk about some of the aspects of your practice and the information that you store in the normal course of business that actually triggers compliance requirements. At the starting point, it's the attorney-client relationship, right? That privilege where all information that is exchanged, all information that you kind of retain, maintain, and collect on behalf of the client and on behalf of their case and the information that you need about their case and their person to help provide, exceptional client services. The confidentiality built into that relationship is essential, so that communication can be open and candid, and you know exactly where things stand so you can provide the best services. What comes with it is a high standard of care, right? Your duty is to protect that information. Now, what information is, triggers compliance versus not? Clearly, some like a social security number or a driver's license or state ID number, financial account information, property information, ownership status, those kind of things. And credit card numbers, all that information, whether it's part of a document you retain where other information within the document is really the purpose for, you having it, simply that information being in your hands and in your, your network, whether it's paper-based or electronic, triggers compliance oftentimes. And that information is often described in two main categories. The first one is personally identifiable information. And really, I want to kind of draw a distinction between name and address and even phone number, potentially email information. Oftentimes, that's publicly available and wouldn't trigger necessarily compliance. But healthcare information, or some of the things I touched on earlier, where it's financial-based, or it's an identification number that used in addition to that individual's name can actually expose them to potential hacking or identity theft or just exposure of that information when it's part of that protected relationship that you have with the client. So I want to kind of just distinguish between the PII, which is identifiable information of a very specific type, and then also health information. And health information is a pretty expansive definition, and that's the PHI there, personal health information. Now that information specifically triggers compliance under the HIPAA, the Health Insurance Portability Insurance Act from 1996, and then the HITECH Act, which really kind of escalated or elevated the protections built into HIPAA and applied it in a broader sense. And that's the Health Information Technology for Economic and Clinical Health Act of 2009. So oftentimes HIPAA and HITECH protections are triggered, and oftentimes there are pitfalls where it's not immediately clear to an attorney that the information that they maintain and have and transmit for their client triggers that compliance, but that's one of the key pitfalls I want to touch on today. Moving on, let's take a look, maybe kind of general, kind of wrapping up or broadening out the understanding of your duty. So at its core, it's really your duty is to take reasonable precautions to apply security to protect the information you hold for your client. Your duty also is to notify in case of a breach, and we'll talk about how that can be mitigated in certain aspects. And then finally, the secure disposal of that information. And that goes to kind of data retention protocols and plans that you may have in place, or if you don't, I strongly recommend that you do implement. Now, the secure disposal of information, that's really at the PII level, because maintaining specific information about a client or even a prospective client oftentimes is important for conflicts check purposes in the future. So you do, oftentimes that secure disposal is not just a universal, select all files and delete. Oftentimes you'll want to maintain certain information about individuals, and that's something that needs to be part of your data retention plan. Okay, and then if the kind of duty is to take reasonable steps, so that reasonableness standard oftentimes is a moving target. It can be defined and kind of and found in different ways, but at the core, it's you taking reasonable steps to assure that the client's electronic information is not lost or destroyed. So once it's kind of shared with you and in your care, you must take reasonable steps to protect it. Now, how do you protect it? Well, that has been defined as either you have the competence to evaluate potential threats to the client's electronic files, or, and this is my recommendation, of course, you retain an expert consultant who does have that competence. And that really is an important aspect to touch on, because clearly your core competency is the practice of law. You can certainly educate yourself, and you should, be kind of aware and abreast of all, kind of technology available to you, but that competence, is it really yours, or is it something that you would prefer to work with a third party who has that expertise, who has the data retention plan, outlines, and they can kind of bring that to bear, or at least help you very quickly implement those types of protocols. And also another a recent kind of enhancement to that that duty, or the description of your duty, is the idea that you must periodically review security measures, right, as technology advances and new threats arise, right? So that's the concept where not only do you need to know kind of the current state of things, but what are threats based on, mobile technology or, cloud-based, use or storage of data. So that's one of the things, that idea that you not only need to become an expert, but also maintain that expertise, or at least that competency. I think that's a pretty high challenge and a significant challenge to a lot of the clients I work with, where, the day-to-day practice of law, needing to be an expert, or at least have that competency and spend time researching and educating yourself. That should be done at some level, but also relying and being able to go out and acquire expertise from individuals who are in business and have a core competency to provide those services to you. That's something where not only understanding your duty, but then also really kind of meeting that duty and really relying on outside expertise for technology applications and leveraging, to protect yourself, as well as informing you and, let's say, your staff, who on a day-to-day basis are interacting with this information that we're describing today, and how they handle it, there needs to be consistency, there needs to be an awareness, right, of what to do, and just as, as important, what not to do, because those pitfalls are not always apparent. And a document may contain some of information that triggers that compliant, even though that information contained in the document is not the core reason for you or your staff, acquiring the document. So it's really a combination of ethical rules, the common law, application of a duty, and also regulatory obligations that can be triggered in some ways without, full awareness of when those triggers happen. So let's take a look at some of those pitfalls. So HIPAA specifically, HIPAA kind of, or the protections of HIPAA oftentimes apply or are covered, or have you, or I'm sorry, those requirements mean that you also fall under HIPAA, specifically because you can become a business associate. Oftentimes there's a business associate agreement. It's a type of contract that's signed to kind of ensure that there's an understanding between the parties. But you, as a subcontractor, or you as an individual who's representing or providing services to an individual who's covered under HIPAA, oftentimes because you are an individual who maintains and transmits, that PHI information, that health information for your client, either as the core, focus of the services you're providing to them, let's say it's elder law or something like that, or as an ancillary bit of information that you use, whether it's litigation-based, general civil litigation, or personal injury, or a workers' comp claim. A lot of law practices involve and include information, right, that you maintain and transmit, and at a federal level, but also the fact that you have that information and are providing services to an individual who, by definition, is covered by HIPAA, means that oftentimes you become a business associate, right? And by doing that, you then have these three main types of safeguards that you must apply to the information that you maintain and transmit for your clients. So let's take a look at those specifically. So there are administrative safeguards, and the two that I kind of called out here are access authorization. And just to kind of unpack that a little bit, or the concept of access authorization, that really means who in your organization needs access to client files and folders of electronic information that contains that PHI, right? So one of the things that is a pitfall is granting access within the organization to everyone, regardless of their role or their responsibility. That can be or can lead to even inadvertent exposures of information. So that access authorization is something that, as an administrative safeguard, I strongly recommend that you only give access to client files and folders to individuals within the organization who truly need it. A second, or an ancillary aspect of that, is login monitoring. You really should have a system, or you need a system where who connects, who accesses files, what they do with those files within your system. There are easy to use software tools that can create logs, kind of audit trails. So not only logging in and connecting to the system, but then what individuals do within the system. I know that seems a little big brother-ish in tracking and monitoring, but it does give you that protection. So you do have an audit trail, and when and if needed, you can determine, who had access, what they did at any point. And finally, password management. The concept of not having passwords that exceed a month or 3 months. It kind of comes down to your protocols. Also using strong passwords, not allowing individuals to kind of select their own passwords, but creating them for them using strong password requirements. That's kind of administrative safeguards I would touch on that not everyone has or applies. Also, physical safeguards. Literally, if you have paper-based documents, are they in a storage cabinet that can be secured with a lock and key? Is your facility protected? Do you lock all the doors? Is there security on place? Are there cameras to protect from a physical standpoint? And also the data itself, making sure or ensuring that you have multiple geographically redundant data backups. And not only that, but those backups are verified, so that you've gone through the process of restoring a backup, even as a test, to ensure that in a disaster, for instance, your responsibility to maintain and protect that information, whether it's a security breach or a natural disaster. Disaster recovery needs to be part of your backup strategy, and backup, of course, geographic redundancy and regular incremental backups and verification of the backups to ensure that no files corrupt, because having a backup that you can't access is no different than not having a backup. And finally, I'll touch on access control, and it's really the concept of each individual within your organization having a unique user ID, no sharing of passwords, no sharing of accounts that exposes you to liability immediately, and also having a system that provides automatic log off. So if someone steps out for a coffee or is called to a meeting or something like that and they don't lock their screen, if they haven't been trained to lock their screen, that's the first thing you do, but also have technology in place that will automatically log them off after a minute of inactivity, 8 minutes. There oftentimes you can set that so it's not intrusive, but it also provides that protection in an automated way. And the final thing I'll touch on is encryption. Encryption now is available for data at rest, data in transit, for your emails, and for the storage of information on your system. I strongly recommend that you avail yourself to encrypting all files within your environment. The networks and storage kind of capacity now means that we're storing more and more and more information. We must use encryption to protect it. And it also mitigates, and we'll talk about this later, but there are ways that if in fact there was a breach, whether you need to notify individuals of that, you can mitigate that simply by having encryption in place. So even if a laptop was stolen or left somewhere and you're not able to retrieve it, if you can prove that the data on it was encrypted using strong encryption, which is available to you now, there are ways to kind of mitigate notice requirements. In an inadvertent stealing of a device or just a loss, somebody who lost it. So those are some HIPAA compliance pitfalls that I wanted to touch on. Now we'll move on to the HITECH Act, which really was an example, or it was an act with the goal being to encourage the use and storage and really sharing of secure sharing, I should note, of electronic health records. From an efficiency standpoint, the HITECH Act was designed to encourage that type of storage. What it also did is it toughened penalties for HIPAA violations. And if you, as a business associate, are required to comply with HIPAA, you also are required to comply with the HITECH Act with its toughened penalties. Some of those, the toughening of penalties, including fine escalation, even criminal penalties, and even unknowing violations, kind of first-time offenders, can lead to fines. So that's something that the HITECH Act, which is kind of a double-edged sword. One, it encouraged and authorized in many ways the use of electronic health records, but then it also upped the ante in protection schemes and making sure that knowing that you're knowing how to comply and that your kind of IT infrastructure and security protocols did comply is something that this act increased the need to comply with. Right. So any business partners who use, store, or process that health information must uphold those security and privacy standards. As I mentioned, it increased the breach notification. In many ways, also defined it in a noteworthy fashion. So if the breach notification is a requirement, and there is a breach on your system, whether it's a hack and some information was taken, or it was a ransomware, and there was encryption, applied to your data from an outside source, it did require, breach. So you would need to notify all clients whose information that you were storing in your environment. It did carve out an exception. I think this is an important thing to discuss because it is a pitfall that is easy for you to protect yourself against. So what it did describe is the rebuttable presumption, and I touched on this earlier with the idea of a laptop being stolen. But even in the situation where a breach happened, you can prove, let's say, a rebuttable presumption that even the data that was acquired, let's say it's an email that was sent to the wrong address, or somebody copied off emails, or ransomware, or whatever kind of the exploit was, they gained access to some information in your system. This is where encryption comes into play. If you can demonstrate that your email communications were encrypted, and the storage of those files and storage of other PII and PHI information is encrypted on your network with bank grade 256 is what I would recommend, AES encryption. That is available to you today. You could have it this afternoon if you don't have it now. Having that encryption protects you in many ways because you can prove a rebuttable presumption that data that was acquired, if it was or not, right? That's one kind of presumption. But should you have an exploit on your system, if that information is encrypted, that it gives you the ability to push back and say the rebuttable presumption is even acquisition of that data does not mean access to it because the communications were encrypted and the data itself was encrypted. So that's something that I think is a common pitfall where you are compliant to a certain aspect, but, and we'll get to this in a second, law firms specifically are being targeted more and more and more because of your high duty of care, because of oftentimes the ethical, legal and compliance regulations that that you're under. You become kind of a target because ransomware specifically, if it's an extortion scheme, the value in protecting that information and retrieving it is such that oftentimes you'll pay a ransom, for instance. Being able to kind of encrypt your information and protect it that way, encrypt it yourself, is a nice way to protect yourself. And also kind of a compliance pitfall with high tech specifically is, once again, it goes back to that audit trail information. It's being able to track and store who has access, of course, from a permissions level, who can, you can grant or restrict access to certain files, but then also being able to track and have logs that show who, based on user account, did access any information that you're storing in your system. So those are some of the things: audit trails, encryption, protecting yourself, and even just kind of knowledge and awareness of how you may become, or how you may fall under these compliance regulations, and then, of course, if that's the case, how to protect yourself. Okay, the next step. So what are some of the repercussions for non-compliance? Clearly, malpractice claims. If it's willful, or if you didn't meet that reasonableness standard, easy for me to say. Also, potentially the loss of your law license. That could be, in a disbarment situation, in an extreme situation where it was multiple, exposures, or if there was kind of careless disregard or no attempt to avail yourself of the information to be competent in understanding how to protect yourself, like you're doing here in this webinar, or leaning on outside expertise to make sure that your current IT protections are not only meet and exceed that standard, but looking down the road a bit, that you've future-proofed yourself because you're working with an organization that knows how to protect you and implement various encryption schemes and mobile access and do the kind of things where no holes are left kind of unprotected, regardless of the use of modern technology. I also want to kind of touch on a couple of the repercussions for HIPAA and high-tech violations. There are civil penalties. These are monetary penalties that are broken into 4 tiers, and the tiers really have to do with kind of start or first instance or repeat or even kind of egregious. You can kind of move to the different tiers. The fines go from $100,000 to $50,000 per initial violation, with a maximum being triggered, and clearly that would be the 4th tier, but that's the $1.5 million fine in civil monetary penalties for non-compliance. Also, there are criminal penalties, right? And of course, that's a higher level, but not protecting yourself, not availing yourself of technology, not being competent, getting the information you need, or relying on someone else to provide that information, as their core competency. Criminal penalties can vary from 1 year to 10 years, whether it's knowing or unknowing, whether you breached that reasonableness standard, whether whether there were false pretenses, in other words, you've lied about your ability to protect that information, or for personal gain. I mean, and that really goes to kind of that malfeasance, where either selling protected information or exposing it, or as for personal gain, right? That's really kind of the highest repercussion. I want to kind of touch on those. So let's get to the kind of the upside of this conversation. What can you do to protect yourself, and what are some of the proactive ways? We touched on a number of different things, as we've gone, and we'll build on those. But here's something that is maybe a splash of cold water to the face. So in this year, the FBI and Gartner came out with a statement that no security is flawless. Now, some of that is maybe a marketing or scare tactic, but the truth is It's becoming more of a when, not if. And the when can vary. How things are exploited, when information may be exposed through inadvertent mistake or malfeasance or internal, a disgruntled employee. There are a number of different scenarios. Now, if it's a when, not if scenario, the first thing I would say is to make sure that you have a cyber insurance policy to protect yourself. Also, that you have a proactive response plan. That seems kind of like an oxymoron, but it's truly protecting yourself by saying, if and when a scenario happens, what do we do, right? Well, have a plan in place. How you would notify individual, what the language would be, how to protect yourself in the language that you share, and who you may need to, contact as well, or who you might not need to contact based on the type of breach that you determine as quickly as possible. And by saying that, the kind of flip side is to avoid a reactive kind of disaster control scenario. And unfortunately, too many of the firms I work with are in that current situation where it is reactive. If something happened, well, then we would figure out what to do. There are ways that you can protect yourself. And here's something that I call out, not to pile on, but to really show you how an example of what not to do. And that's with a recent breach that happened at DLA Piper. And of course, they're a global, highly successful, highly competent law firm. They had a network of data storage and kind of collaborative environments, but a global network of IT that allowed for collaboration and sharing and protecting and kind of applying or providing, I should say, client services. Their Washington, D.C. office, an employee clicked on the wrong link in the wrong email. It installed ransomware that then propagated itself throughout their entire global network. DLA Piper, a high-powered, high-tech, successful firm, was caught flat-footed. And I show you this image on the left because this is what it was reduced to. Instead of having a plan in place, they literally rolled the whiteboards out into the lobby. I believe this is in their DC location. They rolled this whiteboard out in the lobby and with a handwritten note saying, do not turn on your computers. Do not connect to your laptops. Turn off your phones until further notice, no exceptions. That is pretty low tech, but it shows you an organization that had not unlimited resources, but certainly, state-of-the-art industry, or at least availability to state-of-the-art industry, expertise and whatnot, had a network that over time had aged to the point where one weak point created an environment where they had to bring down the entire network for a length of time. Now that hurts your reputation. It's a little embarrassing, but even more than that, it exposes you to liability, and your professional reputation takes a hit. So this is something that you can avoid. And the whole point of me bringing this up is, like I said, not to pile on, but to show you how it's not just a small firm. It's not just a medium-sized firm. It is a global powerhouse that can be brought to its knees when their IT infrastructure is not designed to protect against the very latest attacks. In this case specifically, it was a ransomware attack. So. Some other things to help you plan proactively: have a data retention plan. How data is stored, as we touched on a few times. Who has access to it? You can control that at a very granular level by individual permissions-based access. Also, when and how things are deleted. That data retention plan is not something that you have to, create from scratch. That's something that a security expert, an organization or an entity that is in the business of providing this type of expertise, they have these plans in place. They can implement them in your organization in short order. So I strongly recommend that you avail yourself of that kind of proactive planning. A data retention policy and a plan is one of those aspects. Also, a consistent security plan, not allowing individuals to use Dropbox for one case and Gmail for another. Or having individuals install programs that they use but are not authorized or vetted or protected with a consistent kind of firm-wide security plan. Just like that data retention plan, there are expertise, there are consultants, there are entities that have these plans in place and can help you implement them quickly and provide training to your staff. The training aspect is extremely important because even with the very best protections in place, the weak point in all security is individuals. It's the people who actually touch the documents, who touch that information, who transmit it, maintain it, collect it for you. So training, I should have underlined that, becomes an important aspect. And the training is becoming better, meaning it's not just dry, highly technical training. Instead, in order to get those messages, what to do, what not to do, common scenarios, the training is becoming much better in delivering these kind of proactively scenarios that help you and your staff protect the firm as a whole and also your client information. Also, just some core, basic information, protecting the facility. Don't put a fax machine or a printer that might, have information or a scanner or a copier in a common area or a publicly accessible area. That, sometimes that seems like common sense, but take a look around. Many people don't have that in place. Also, I would say, and this is kind of, some people argue about this point, but I would recommend that you do not use Yahoo, Gmail, or LinkedIn for email. The reason I say that is not because security, flaws are inherent in those systems, but some of the revenue or the model for generating revenue is to, and they'll claim it's anonymously scour your email in order to better provide you with, kind of tailored or targeted marketing. But the scouring of that information, it's kind of a gray area now, but it does touch any information that you receive via those, those email services, information that you may receive from a client or from a third party that has to do with the client. The information can trigger your compliance requirements. So I would recommend that you go with a secure and business class email provider. That's just kind of my personal recommendation to you. Okay, the final slide, I'll touch on some other protections available. This is important. It's a concept of separating IT break-fix support, where, does the hardware work? Can you log in? Do you have an internet connection? Is your email working? That kind of concept of things running smoothly. I'd like to kind of have you understand the concept of separating that from the security protocols and retention policies and the training and what to do, because it's almost like having your IT up and running is one aspect of it, but how to use it and how not to use it is a separate important protection. So I want to kind of determine or touch on that. I would also recommend an ISO or NIST based security audit. If you haven't done one, or if you haven't done one in the last 2 years, I would recommend that you reach out and have one performed. It's a straightforward process. They can, one, take a look at your hardware. One, they can actually share with you those retention plans and security kind of protocols or policies. It's a good way for you to benefit from organizations, the ISO or the NIST, that provide you very specific kind of information about your environment. And that security audit is something that is easily accessible to you, and the information is invaluable because it can point out glaring flaws that you might not be aware of, those weak points. And all it takes is really one weak point to bring down the whole network. And of course, I keep kind of beating this drum, but engage data security and IT experts. The expertise is there. Avail yourself of it, and that helps you comply immediately with that reasonableness standard. Another thing I wanted to touch on, and this is the kind of, just like I touched on the backup, a backup is only as good as the last time you checked that one, the files were protected and available, and two, that you could restore them. Similarly, if you apply a data retention plan or you apply a consistent security plan, you should test it. And here's an anecdote that I share often, but it still drives me crazy. There was a ransomware test done recently. So, a group I'm familiar with went to an organization. It was a law firm, and they gave a morning-wide kind of 3-hour. Here's security, best practices, and here's how ransomware can affect your network. Here's what to do. Here's what not to do. 2 days later, as part of a test, they sent within the organization an email that purported to be from not the group that did the training, but from the firm's IT, saying, all right, dear firm, and it was kind of the language vague, but the point was a phishing email was sent to the firm as a test. 78% of that firm clicked on the link in that email that would have, in a ransomware actual scenario, infected their network. So that's the idea, where, not only the security plan and the training, but also test it. And oftentimes, if you're doing one of those security audits, the organization that you go with can actually help you perform those tests. And sometimes it's it's a scare tactic, but knowing what to do and what not to do and making sure that individuals have that in mind is a good way to protect yourself. Also, an incident response plan, I touched on that earlier. That's something that can be provided to you with template language and ways both on your jurisdiction, because sometimes there's variations in the need to notify, but your security experts can provide that information for you. Once again, encrypt your data and your email. There are a number of different email and encryption providers available. Office 365 is one that has relatively easy to use encryption that you can apply to your emails, specifically to clients or all emails. You can kind of very quickly, enable encryption to any outgoing email. That's a nice way for you to kind of protect yourself. I also strongly recommend virtualization of your network infrastructure. And what that really means is taking your environment into a secure private cloud. It's available to you. You know that environment with built-in controls and 24/7 monitoring, it's something that Abacus Next does. This is something where you can immediately know that you are compliant, that your technology, that the data in your environment and any applications and the training that that's provided with it means that you can check your lists of being in compliance and having a virtualized network. And that virtualization is also important because it means that the entire system can be reset, let's say within half an hour, back to the last good prior state. And that is at the database level, at the program level, at the operating system level. Literally every individual's virtual work computer can be restored as kind of an advantage and an efficiency over what you're currently, in your current disaster recovery or business continuity plan. So that virtualization, I think, is the future, and it's in the next, let's say, 2 to 5 years, I think everyone will move into that type of environment because maintaining that same level of protection on a local basis requires resources that oftentimes exceed the capabilities of firms, right, of small to medium-sized firms. But you can kind of leverage that same technology by moving into a private cloud environment. Also, if you allow, or a lot of firms are moving towards kind of bring your own device, I strongly recommend that permissions, what those devices, you can authorize them at a MAC address level as a way of protecting yourself instead of just giving everyone kind of very flexible permissions, using their own device. There's a way of kind of locking that down where, you can use a Mac, you could use a tablet, you can use a Chromebook or a Windows machine. There's flexibility available to you, but you also can control that at a permissions level, so the device itself is authorized and what the individual who logs into that device with multi-factor authentication is something that I strongly recommend. Those permissions are important, and that's something that a security expert can help you with. The last thing I'll kind of touch on is endpoint antivirus and malware. Look into your current antivirus and ensure that it's endpoint based. What that really means is the device itself may not connect to the network as an endpoint unless it has been vetted, validated, and as authorized to do so. It's kind of flipping the idea of a device having a software app installed on it that does antivirus and malware scanning. Instead, the endpoint does not let that machine, that hardware endpoint, connect to the environment until and unless it's been authorized. And so that's one protection advantage. Also, the antivirus and malware definitions, the updates to how the scan, or what the scan is looking for, that happens at a network level. So the updates are pushed out, and it's not that one device has been updated, the next device hasn't. Instead, all devices are updated consistently. So that endpoint, specifically, that's a term of art there, antivirus and malware is important. I strongly recommend that you avail yourself of that. And finally, it's just being, common sense. One of the things that you can do is to decline to include PHI or PII, for instance, a social security number in a document that you e-file. There are many documents that ask for that type of information, and based on your jurisdiction, you are able to decline to enter any information that is not required. Right, so that's one of the things where kind of protecting yourself by maintaining and determining when you transmit information for your client, and of course what information that you transmit.